Hey guys, welcome to this video. My name is John Watson. I'm a consumer protection lawyer. And we get a lot of questions from folks either that we represent or even other folks that say, hey, look, I've been sued by a debt collector. So Midland or LVNV, Portfolio Recovery, whoever it might be, they've sued me. I've got a lawyer. Does my lawyer want me there at trial? Now, for our own clients, we certainly communicate with them directly and tell them. But I know this is a question a lot of people have because, on the one hand, we're always harping about if you miss your trial date, you lose. They get a default judgment against you. But does that change if you have a lawyer? And I'll just tell you, for us, it changes. We typically do not want our clients at trial. There's really no reason for our clients to be at trial in a debt collection suit. And let me explain why. Because we're dealing with a company like Midland Funding, LVNV, Portfolio Recovery, Calvary, Unifund, whoever it might be. They claim to have bought a debt that my client owed. But they have to prove that this debt buyer must prove it actually owns the debt. Now, what can my client say about that? In other words, can my client raise his or her hand and swear or affirm to tell the truth and start testifying with personal knowledge about whether or not this company really owns the debt? My client has no way of knowing that. Okay? That's knowledge that's only known to maybe the creditor and this debt buyer who claims to have bought the debt. And so my client really has nothing to say about that. And they're not supposed to speculate. So I don't want my clients there speculate. Now, the collection lawyers would love if every trial my clients were there, because what they're trying to do is trick the defendant. Okay, whether it's me as a lawyer or somebody else as a lawyer, they're trying to trick the defended consumer into saying, yes, Unifund owns this debt. Yes, Midland bought this debt. Yes, I owe Portfolio. Well, you have no way of knowing that as a consumer. That's just speculation to say that. So why would I want my client to be at trial when there's a chance that they would start speculating about things that they don't know? Well, I don't. And so for many years, we've had this policy of we just, unless there's something unusual, we don't want our client at trial. Now, we show up for our client, okay? But we have no obligation to bring our client there unless we're trying to prove something. Maybe it's a statute of limitation defense and we need our client to testify about when a last payment was made or when things sort of went off the tracks and to show that, hey, too much time has gone by from when we stopped paying to the time the lawsuit was filed, and so we have a valid statute of limitations defense. But other than that, we're not going to have our client there unless it's to our advantage. So obviously, if we represent you, we'll have this conversation. But if you're represented by another lawyer and you happen to be watching this video, or maybe you have not yet hired a lawyer, I would ask your lawyer to say, hey, what do you want? Is it helpful for me to be there? Do you not want me to be there? What's the best thing for my case? And look, you trust your lawyer. If your lawyer says, look, I need you to be there, this will help us, then, you dance with the one that brung you, okay? You follow your lawyer's lead on that. But I'll just tell you, from my vantage point, where we're making these debt buyers prove that they own the debt, then there's no reason to have my client there. And so we typically do not do that. So hope that answers that question and you found that helpful, and we'll catch you in the next video. Okay, bye-bye.